All rise. The Court of Appeal for the State of Florida is now in session. The Honorable Vincent G. Forty Jr., Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right, good morning. Welcome to oral argument session of the District Court of Appeal for the 5th District. As the Marshal said, I'm Judge Torpy. I'm presiding, not because I'm the oldest judge, I'm the most senior judge on the panel. I'm joined today, I have the pleasure of working with Judge Evander to my right and Judge Wallace to my left. You all can figure out which of those is the oldest member of the panel. We have 3 cases that are left on our docket, all civil cases. There'll be 20 minutes per side. If anyone is here on Quinones, Alea Quinones versus State, Puchek versus 458 Mortgage Company, Bavaro versus Taylor, those cases have been dispensed with or canceled. And you'll need to see the clerk about them because we're not going to be hearing those cases this morning. We're going to take the cases on in the order that they appear on the docket. If anybody has any noise-making devices, I know that they have counseled you about that when you came through security, but please double-check them. I double-checked mine because mine has gone off sometimes during oral arguments, so please double-check them so that we know that we have nothing that's going to interfere with the arguments of the attorneys. The first case on the docket is St. John's RIVERKEEPER, and I see we have two lawyers on that side. Are you all splitting your time, or how are you all handling it?
We are.
Okay, and you've worked that out, right? Okay. All right, when the appellant is ready to proceed, you may proceed in that case. How much rebuttal time do you think you want, Counselor?
8 minutes, please.
8 minutes?
Yes.
Okay. The clock is going.
Good morning. My name is Marcy Lahart. I represent the St. John RIVERKEEPER and Florida Defenders of the Environment. On behalf of my clients, I am requesting that you reverse a final order of the St. Johns River Water Management District that grants a permit to withdraw 1.46 million gallons of water per day for a grass-fed beef operation until 2034. We're asking that you reverse this decision because it was based upon fiction.
Your point 1 has to do with Dr. Kincaid. Was that his name? Oh, what is your point 1 in your brief?
My point 1 in my brief is that the administrative law judge erred in not allowing us to produce evidence as to the district's proposed denial of a additional allocation or additional requested withdrawal of another 1.12 million gallons of water a day.
Right. And that came up during the testimony of one of your experts, right?
That did come up during the testimony of one of our experts. However, the administrative law judge made it very clear that he felt that that was irrelevant and that he was not going to consider.
Right, but you were asking your expert about it because it had some impact on your expert's opinion, is that right?
Yes.
I mean, it was an historical fact upon which your expert was going to base his opinion, is that right?
Part of his opinion, yes.
Who was the expert?
Dr. Kincaid?
Okay, I thought it was, but when I asked you that to begin with, I thought maybe I was mixing my cases up.
No, your question threw me a bit.
How did the exclusion of the evidence affect Dr. Kincaid's ability to give the opinions that you expected him to give in the hearing?
It wasn't so much that it impacted Dr. Kincaid's testimony as it impacted our testimony to explore with district witnesses their reasons for differentially treating withdrawals.
But the only way you can get all of these facts into evidence through the opinion of an expert is if it has some bearing on the expert's opinion. If the expert, in this case, if Dr. Kincaid gave the opinion that you wanted him to give and expected him to give, then the fact that he was not able to talk about underlying facts upon which his opinion was based didn't prejudice your client at all, did it?
It did prejudice our client in that we were limited in the scope of testimony that we were allowed to produce. We were not allowed to further explore the reality that the region from where these withdrawals will be taken is over-allocated already, and those over-allocations, groundwater pumping is already causing harm to Silver Springs, including changes in water quality, water clarity.
Did you not have an obligation to proffer at that point once the judge excluded the evidence?
We did proffer by putting into the record, into evidence, the corporate representative depositions of 2 district witnesses.
And that evidence came in without objection, right?
It was over objection.
It came in, the objection was overruled.
Correct.
Okay, so you got your evidence in then, in another way then, right?
But that evidence was not considered by the administrative law judge, and he made it clear that he wasn't going to consider it.
Mm-hmm.
In fact, if I can read to you from the transcript.
At the time you offered it, did you offer it as a proffer for the excluded evidence during Dr. Kincaid's testimony? Did you say this is I remember that during the testimony, you said, we want to make a proffer, and the administrative law judge said, fine, do it later. When you did it later, did you do it in the form of a proffer? Did you say, okay, I'm offering this as a proffer?
We did not specifically use the word proffer. We effectively proffered the evidence that we wanted to put in the record by putting the corporate representative's deposition in. The administrative law judge said to my co-counsel, Mr. Thomas, he said, Your Honor, I don't know how we go forward without talking about the 1.2 million gallon a day withdrawal. The judge said, well, you're going to need to figure out how to go forward. Mr. Thomas, I've sustained the objection. That's the end of the discussion. Let's move on. We did not continue poking that bear. Instead, we put the corporate representatives' depositions into the record.
But didn't the hearing officer also say that, he wasn't precluding you from impeaching the Water Management District's experts or Sleepy Creek's experts if it was relevant to their testimony? So during the testimony of opposing experts, did you all ever try to impeach their testimony to indicate that something they were saying was contrary to what they may have said with regard to this denied application? Was there ever an attempt to impeach with a proffer they were saying, Mr. Hearing Officer, if we could proffer this time and show what we would have done to impeach these experts?
We did not, as I said, continue to poke the bear. The administrative law judge made it clear that he felt that any discussion of the additional withdrawal was irrelevant. We felt that through the corporate representatives' depositions, sworn testimony, we had shown that had the Water Management District relied upon the improved modeling and had they considered the change in environmental conditions since 2001 and 2004 when the modified permits were first issued, that the result would have been a recommendation of denial.
You said you didn't want to poke the bear, but the hearing officer said, and then to the extent that there's something that needs to be impeached, impeach them, but I have to have a piece of relevant evidence before me that would then be subject to impeachment.
And he had uniformly said that he saw no relevancy in the 1.2 million gallon per day withdrawal.
Well, no, what he said was he didn't see any relevancy on that issue alone unless it could be made relevant to the current application. I mean, would you agree that's what he said?
I don't recall him using those specific words, but I'm certainly not going to argue with you if that's what you tell me.
Let me ask you this. If you win on this appeal, and if we reverse and remand and direct the agency to deny the permit, does Sleepy Creek still have the right to withdraw 1.46 million gallons of water per day under their existing permits?
They have the right to withdraw 1.46 million gallons a day, but there is no competent substantial evidence in the record that they could make a reasonable beneficial use of 1.46 million gallons of water a day on the East Tract.
Right, but they have a permit now.
Mm-hmm.
So again, if we agree with you and reverse, do they have the right at this time to withdraw 1.46 million gallons of water per day?
They would have to show that they have a reasonable beneficial use for 1.46 million gallons of water a
Or
day.
did they already show that when they got the permits in the first place?
They showed that they have a reasonable beneficial use for 1.46 million gallons a day on 2 tracts of land, not solely on the east tract.
Okay.
But the new permit gives them the opportunity to do that for a longer period of time, right? It essentially extended their right of use of the water, right?
The new permit allows them to use a portion of the 1.46 million gallons of water per day on the north tract, which is further away. But it also allows them to extend that use until 2034, and it would have expired in 2024. And
Okay, Council, go ahead with whatever other points you wanted to make.
Thank
Well,
you.
let me go back to this, but the 2034 can be reviewed at 2024 to see if there is being harm to the environment.
well, it could be reviewed at any time to see if there's harm being caused to the environment. But the reality is that as the district's head of regulation testified, that in his long history with the Water Management District, no permit holder has ever been required to reduce their withdrawal because of harm to the environment.
Let me ask you this. The administrative law judge seemed to find that if they used 1.46 million gallons of water per day under the new permit versus, in a way where it was from 2 tracts rather than all on 1 tract as previously, that if they use 1.46 million on the new permit as opposed to the 1.46 million drawn from different locations under the old permit, that it would have less of an environmental impact under the new permit as the old. Would you agree or disagree with that determination by the administrative law judge?
I disagree with that determination by the administrative law judge, because the use that Sleepy Creek is going to make is 5 times what the previous permit holder was using historically.
Well, that was my question, though. My question was, if they use 1.46 million, if they used it all, I know they're not now, but if they used it all under the old permit versus using that amount, 1.46 million, under the new permit, would it have a worse impact on, which would have a worse impact on Silver Springs?
They are still allowed to use up to 500,000 gallons of water a day on the east tract, which is more than was historically used on the east tract. So their use will be more detrimental to the environment than the prior use. By focusing,
But I'm not saying the prior use, I'm asking the prior permitted use.
well, the face value of the permit, if you focus only on the face value of the permit and ignore the reality that the permit holder only used about 1/5 of the allocation, then yes, the modified permit would be less detrimental to the environment.
Okay.
But that would-
And so that's the problem I have with your argument, is because it's a permitted use, if we agree with you and remand and say deny the permit, and the property owner then uses the full amount of their permitted use, it seems like it would have a worse environmental impact. And so I'm trying to see how a win here, if you would, on appeal would help your client.
A win here on appeal would help my client, in that the Sleepy Creek has never shown that they have a need to use 1.46 million gallons of water a day on the east tract. And there is a difference between a permitted use and an existing use. The existing use was only 0.3 million gallons a day.
So your hope is that if we agree with you in reverse, that even though they're permitted to use 1.46 million on the old permit, they probably won't. They'll continue
Yes.
to not use it.
Exactly.
But legally, if they did, then you'd be worse off.
Legally, they would still have to show that they have a need for 1.46 million gallons of water on the east tract, and I don't think that they can show that,
But
at
didn't
least
they
not for a
already show it
grass-fed
when they-
beef
They already
operation.
show it when they got the permit?
You're mixing apples and oranges, Your Honor. They showed a need for 1.46 million gallons a day, but 0.96 of that is, up to 0.96 of that may be used on the east tract. They're only allowed to use
I understand that. I'm talking about
Okay.
the combined amount. I mean, if the permit got denied, they could go back and use 1.46 million, even though it would be divided in a different way as far as which tracts. But they haven't in the past, but why couldn't they then use it under their existing conditional use permits?
They don't have a need for it on the east tract. the Water Management District issued permits that had a face value of 5 times what the sod farmers needed, even if Sleepy Creek needs more water than the 0.3 million gallons a day for their grass-fed beef operation, they did not show that they need 1.46 million gallons a day on the east tract. Therefore, they would not legally be entitled to a modification to change the use of the water
Okay,
to the
you're
east
saying
tract.
they didn't show it when they got the original conditional consumptive use permit? mean,
I don't
somehow they
understand
got
your
a-
question.
Somehow they got approved for 1.46 million between the two tracks originally.
No. There was 2 permits that allowed the withdrawal of 1.46 million gallons a day on the east tract. There is no permit for the north tract.
Right, but for the east track, somehow they got a permit, and they would have had to show a reasonable beneficial use to get that permit. At least arguably, they were required to do it. Whether the permit was granted correctly or incorrectly is not before us. But on the east track, they got approved for that and would have had to have shown the elements, right?
Sleepy Creek did not get approved for 1.46 million gallons a day. 2 sod farmers got approved for 1.46 million gallons of water a day. To modify that permit to allow Sleepy Creek to use it for a different land use, the Water Management District would have been required to consider whether they needed all of that water for a grass-fed beef operation for the east tract. They didn't ask that question. I think one of the most important points for you to consider is whether this use is in the public interest, and the fact that the administrative law judge didn't consider whether it was in the public interest based upon the criteria that he was directed by law to consider. What he considered was that the withdrawal would be in Sleepy Creek's financial best interest, that it would allow them to have a better return on their investment than if they had a ordinary cow-calf operation, as is traditional in Florida. What he was supposed to have considered was whether the use would be detrimental or beneficial to the overall collective well-being of the people, as well as to the water resources of the district. Because he did not understand that that criteria applied to this case, there is not one single finding of fact in the record that found that Sleepy Creek's proposed use is beneficial to the people in general. The Water Management District says that there are other things in the record that support the conclusion that the use is in the public interest. However, there is nothing in the record regarding the specific factors that the administrative law judge was required to consider and weigh and balance.
Did the administrative law judge make a finding or have evidence before him that denial of the permit would adversely affect the quality of the water in Silver Springs?
I'm sorry, I don't understand your question.
Did the administrative law judge have the benefit of evidence before him and make a finding that the denial of the modification would have an adverse effect on Silver Springs or the water in Silver Springs?
The administrative law judge made a finding that by moving part of the allocation from the east tract to the north tract, there would be a benefit to Silver Springs. However, that ignored the fact that the Sleepy Creek would be using 5 times more water than the prior permit holder had used.
So his focus was on the quality of the water, correct?
Yes,
Okay, so is that a benefit?
potentially, yes. But was there a specific finding made that that benefit outweighed the harm of granting a permit from an already over-allocated system and extending the duration of that permit for 13 years? The administrative law judge did not explicitly weigh and balance those considerations as he was required to do in making a recommendation to the Water Management District.
All right, you got a little over 3 minutes. You want to save that time.
I'd like to point out that when the Water Management District considers a modification, they are tasked with considering how the environmental conditions have changed since the prior permit was issued. And they may not ignore better evidence regarding contributions of groundwater pumping to environmental harm that they have learned since the initial permits were issued. The environmental conditions have deteriorated since 2001 and 2004, when these permits were originally issued. But the Water Management District put a lot of emphasis in saying that this was an existing use. It wasn't an existing use, it was a permitted use that had never been fully used. It's clear that in the course of considering Sleepy Creek's additional...
You misunderstood me. You've only got about 2 minutes left. Do you want to save rebuttal time?
Yes, thank you.
Okay, all right. You got just a little less than 2 minutes in rebuttal time, Counselor.
Thank you.
Yes, ma'am. All right. And how have you allocated your time, sir?
Pardon me?
How have you and council allocated your 20 minutes?
May it please the court, Sleepy Creek and council have decided to allocate 10 minutes apiece. I will try to save more time.
Okay, you've got 20 minutes on the clock. When it gets to 10 minutes, I'm going to warn you that you're into council's time, all right?
Thank you, Your Honor.
All right, sir, you may.
May it please the court, I'm John Wharton, Dean Meaden Dunbar, Tallahassee, on behalf of Applee and the applicant Sleepy Creek. I do want to quickly address a couple of questions that came up. Judge Torpy, we don't know whether the exclusion, if in fact that is the right word, of this evidence affected Dr. Kincaid's testimony. I tend to look at it like a trial lawyer.
She said it didn't.
Pardon?
She said that it did not affect the opinions that he gave.
Okay, because...
I don't know why you'd even argue
Because they
that.
did not take advantage of the proffer, in which then we would have a record on, this is what I would have said. In fact, the judge never closed the door. The judge said, if you can just explain to me why this other application, Sleepy Creek hasn't even filed a protest against the denial of, for new water on the North Track relates to this relocation issue, we can revisit it. In
Let me
fact,
ask you something. I might be wrong about this, but it seems as if there was a lot of testimony about the subsurface conditions on the north parcel, and specifically the extent to which there would be percolation into the aquifer on the north parcel. Is that because the permit, you needed a permit for the use on the north parcel as well as the extraction of water?
it's an interesting point, Judge. In order to extract water, you would want to know the effect on Silver Springs, which was 12 miles to the south. That is the quantity portion of the case.
Right.
This case also had a quality portion. St.
Right, but you
John's...
got fertilizer.
St. John's is unique among the districts in that they do look at the effect on the water resources of the use.
Right.
If we just had a non-grass-fed cattle ranch, we could have put 15,000 cows out there and never gone to St. John's for anything. This case is really not about water for cattle, it's about water for crops, because anything less than 12 inches, even if it's a piece of corn, is considered grass by the FDA for grass-fed beef. So that was why the district was looking into that, and Sleepy Creek, in fact, put 35,000 feet of berms out there and et cetera to meet that.
Right, so the bottom line on the north parcel is that that there was not going to be a great deal of percolation because of the layer of clay and sand above the limestone, if there was any limestone, and because of the slope of the north parcel. Is that right? Is that the bottom line on that?
That's correct, Your Honor. That's
So
correct.
but that would have had to do with contaminating the water in the aquifer, not necessarily the effect on Silver Springs, the quantum of water that Silver
Correct.
Springs.
It was widely acknowledged that, as Judge Evander noted, that moving the withdrawals from the east tract north to the north tract would have a small effect to increase the flow at Silver Springs, therefore benefiting the spring. But the water quality concerns the ALJ determined had been taken care of by the nature of the land, the hydrogeology, the soils, the things that Sleepy Creek was going to do to assure that there was not a problem in that regard. Two issues I just want to hit as briefly as I can, Your Honors, and that is...
Where do you think that the, zero me in on the ALJ's finding about the public interest issue.
The ALJ's findings of,
Council's point that the ALJ didn't properly weigh the public interest.
that to me is an issue that, much like the truncated review issue, council has gone in and they have looked at a single line in this 139-page recommended order that says the primary basis upon which Sleepy Creek relies to demonstrate the CUP is consistent with the public interest is that Florida's economy needs agriculture and there will be jobs and food production. Well, we weren't just going to get up there and testify, hey, we're agriculture. We were describing the benefits that we do, but we were also very, very careful to make sure that our testimony fairly met the traditional district definition of public interest, in that the use would be efficient, it was a legitimate use, agriculture, and that there would be no adverse impact on the water resources of the region. And the ALJ found that exactly. So there were a lot of references in the record about why this was in the public interest. I personally don't think it was error. That's the only thing I disagree with the district on, for the judge to take into account the economic effect of the ranch. But because I think public interest could be interpreted more broadly under the statute, but under the way it has been interpreted, there was a plethora of evidence in the thousands of pages of documents that were put in for the truth of the matter asserted, 5 days of technical testimony. We were very aware of that standard, and there is a lot of findings of facts that are supportive of that it is efficient, that it is a legitimate use, and that there will have no adverse impact on the water resources of the country. So, and again, of the region rather. I'm not sure the judge really excluded it. He actually let in quite a bit of testimony about this other application that Sleepy Creek, in fact, was a proposed agency action, and Sleepy Creek never challenged, and I think left open the door for more. But even so, none of the findings of facts on which that the judge found and that the district said this clearly fits within the way that we determine the public interest test has been met, have been under challenge in this brief in any way. So certainly that was not the only.
So these cattle are, instead of being shipped to Texas or Kansas for finishing and slaughtering, are going to remain here. Did they, from the difference between, what was it, 875 pounds is when traditionally they're shipped out for fattening and slaughter, is that, but here they're gonna grow to their full size and then be slaughtered, is that?
Correct. And I think there was.
And usually, as I understand the evidence, at 875, historically, when they're shipped out, then they're fed grain and fattened up. How do you get from the 875 to the 1150 in this operation?
Now, these beef are going to be no hormone and no antibiotics on the grass-fed on Sleepy Creek ranch, but they are fed with various things up in the Midwest that they do gain a significant amount of their weight, about a third, this is all in the record, quite quickly. And we did argue that a variety of the aspects of what we were proposing to do did fit within the public interest, which has alarmed the appellates because they're saying it's economic.
How do you get them above the 875 in your operation?
We just leave them out there.
Just keep eating grass.
The scheme at Sleepy Creek, Your Honor, is that the cows just move from pivot to pivot to pivot to pivot over the course of their lives, and eventually they're in the pivot right beside the abattoir. Mm-hmm. And we have a Temple Grandland designed ramp so that they will stay calm, and at that point they're at the finishing weight. So we characterize the public interest as involving more than just the efficiency of the use and the legitimacy of the demand, and that the resources would not be affected. And I think that the appellants have then confused that and said, well, here's this stuff that we don't think should fit in that category. But in fact, the record is replete with support for those particular findings of facts. The only thing I would do very quickly in the minute I've got left is one of the three issues was that this was somehow submitted to a truncated review. This, again, is very similar to the failure to proffer. In the deposition where that statement was made, and by the way, it's not an illogical statement, hey, if it's a modification of a permit, then we're not going to re-review the things you're not modifying. They've already been proposed agency action and have become final. But he said, I could take you through this, and criteria by criteria, do you want to do that? And they said, no. In fact, this hearing was part of the review under the case law. This application was submitted to every single criteria. The case was about every single criteria. The recommended order and final order were about every single criteria. And I'm not here arguing with you today, well, we shouldn't be looking at these criteria because this is a modification. And everything was on the table all the way through. So I don't think that is, that issue rises to one that the court should consider very seriously, given the fact that this case was a full review in all respects. Well, thank you for your time, Your Honor.
All right, thank you.
May it please the court, my name is Mary Ellen Winkler, and I represent the appellee St. Johns River Water Management District in this case. And I wanted to take a few moments to address some of the questions that you had. First, I believe Judge Evander asked about what would happen if this permit, if this court decided to reverse the final order. Sleepy Creek would have 2 valid permits for 1.46 MGD for a sod farm. That's what they had coming into this case, and if this case were reversed, that's what they would still have.
But they can't use that water to grow grass on the north parcel for cattle, right?
That would be correct. They would only have 1.46 MGD to grow sod on the east tract. And for the court's convenience, in the appendix that I filed in A1 through A3, there's some maps of the different tracts to orient you. They were exhibits at trial. In addition, the appellants make a great deal about the actual use, that they only actually use 0.3 MGD for the sod farm. And I should point out that these allocations, these are both sod farm and the irrigation for crops, are all drought allocations. So the district allocates water for a 2 and 10 year drought. So we would not expect a user to use the full amount of the allocation every year. So these are drought allocations, so it's supplemental irrigation. So you expect on average a certain amount of rainfall, and if you don't get it, this is the additional water to make up for what's needed to grow those crops or grow the sod. So I did want to clarify that point.
So on the new permit for the cattle grazing, is there an expectation that they would not use 1.46 million?
Not every year. It's a 2 and 10 year drought allocation. So what we do as part of our analysis, and again, if the appellants, if we took the actual use argument to its full extent, we would then have to, if we're going to evaluate the 0.3, then everybody in the model, which is the regional model that we use to evaluate the permit, then everyone else would be at actual use too. But instead, and it's in the record in this case, what we do is we evaluate the permit in a very conservative way. We basically have everyone at their end of permit, EOP use, which means everybody's at their max quantity. What happens to the water resource if we put everyone at their max quantity? So that's how we do the evaluation, because from year to year, depending on rainfall, that actual use can change. So I did want to clarify that point for the court.
Let me ask you about the finding that the ALJ made at paragraph 283. If the CUP modification is denied, the existing CUP will continue to allow the extraction of 1.46 gallons per day for use on the east tract. The preponderance of the evidence suggests that such a use would have greater impacts on the water levels at Silver Springs, and that the continued use of the east tract as a less stringently controlled sod farm would have a greater likelihood of higher nutrients levels, particularly phosphorus levels, which are already elevated. Is that an accurate finding, do you think?
We believe so, Your Honor. In this case, the applicant...
I mean, the denial leaves them at status quo, which is with the sod farm on the east parcel. They can't do anything on the north parcel, right?
Correct. What they could do on the, as...
Not using the 1.46, and they probably never would for a sod farm. They're growing all the sod they can grow over there, right?
Well, they could, if they chose, the applicant could choose, as Mr. Wharton indicated, they could have a regular cow-calf operation without additional, so they could do that on the north tract, and they could go back to sod if they so chose with those two, if you reverse. So they would have those options.
Hold on a second. Maybe you're not getting what, it seems like what the ALJ's saying here is that if I leave them status quo, they're having more of an impact on Silver Spring because they're drawing 1.46 for their sod operation, when indeed we know that they weren't drawing anywhere close to that. And I didn't see any testimony that there was any change in use or proposed change in use of the east tract for a sod farm that would result in a higher quantum of water being taken there. I mean, a materially higher quantum. So that it seems as if this finding is erroneous.
No, I think what, Your Honor, the administrative law judge, what he's saying is that based on the permitted quantities, and that's how we evaluate everyone, we assume that everyone is going to use their maximum allocation because they had been using 0.3 MGD, the prior owner of the permits.
How are they going to ever use more water than they're using to grow sod?
Perhaps.
Assume that they're maxing out. I mean, this is a for-profit business. They're producing as much sod on the east tract as they possibly can produce, right?
It depends on rainfall, Your Honor. If we had a significant drought, if we were having the California situation where you're not having rainfall, they may max out the allocation. It really depends on if they're having sufficient rain, then the sod could be grown with the 0.3. If we had a situation like California where you're having, a 100-year drought, a significant drought, then they may need that full allocation to make their crops work. It's really whether they use that full allocation, particularly in the agricultural context, is heavily dependent on what the rainfall is.
How many years has the sod farm been in operation?
I don't know. I know that they had those permits originally issued in the early 2000s, and there were previous sequences. I don't know, Your Honor, and could supply that if you liked, but I don't recall.
Go ahead, ma'am.
Okay, thank you, Your Honor. The other thing I wanted to mention briefly was the public interest test. The way that the district has evaluated the public interest test, and there's a case, Marion County versus Green, from this district, and we have several final orders quoted in our brief. We have looked at the public interest test in our evaluation, whether the use is for a legitimate purpose, whether the use meets the reasonable beneficial criteria, and whether any of the reasons for denial of a permit exist. And that obviously necessarily encompasses a lot of findings of fact that are throughout the recommended order. So while we agree with the appellant from the standpoint of we believe that our public interest considerations are to water resource related matters, the governing board in its final order made clear that it looked at those findings related to economics just from a standpoint of it was the use is for a legitimate purpose. No additional findings were needed. And the appellants failed to identify that what findings did the governing board make up. There's no allegation. There was plenty throughout the recommended order for the governing board to make the determination based on the case law that this project was in the public interest. It was reasonable beneficial. It was for a legitimate purpose, and none of the reasons for recommendation of denial existed. Your Honor, for For all of those foregoing reasons, we respectfully request that this court uphold the final order of the Water Management District.
All right, thank you, counsel.
Thank you, Your Honor.
All right, you have just under 2 minutes.
I'll talk fast. It doesn't surprise me that Mr. Warden thinks that his client's economic bottom line should be considered in the public interest. As a matter of law, it must not be. The district's final order in talking about how the administrative law judge misapplied the public interest test referred to it as the conflation of public interest tests. I had to look that word up. With all due respect to Ms. Winkler, it's a three-prong test. The first test considers whether it is a reasonable beneficial use. In other words, is it for a legitimate purpose? The second prong asks whether the use affects other existing legal uses, but there's still a third part, a public interest test that is separate and apart from the reasonable beneficial test, separate and apart from whether it is a legitimate purpose, that looks at the impact of that withdrawal on
What prongs are you challenging?
the third prong.
Just the third.
Just the third prong. As in regards to the truncated review, our position is that the Water Management District was required to apply all of the criteria, and we're not arguing that they didn't apply all of the right criteria, but they needed to reconsider the use based upon changed environmental conditions rather than with the foregone conclusion that this is an existing legal use that must be allowed to continue, which seemed to be the position that they were taking. In summary, the Water Management District itself has said that it's okay to withdraw 0.96 million gallons of water a day from the North Track, that won't cause environmental harm. But if you withdraw 1.12 million gallons a day above that from the same tract, that it will cause harm to Silver Springs. Mary Ellen Wilkler testified as to how, or spoke about how the district is conservative.
Counsel, you're out of time.
Thank you.
Thank you.